I'm looking at this ruling, and I want to understand the logic behind it. Can you explain that?
Yeah, in addition to the plaintiff states, there were also plaintiff individuals who alleged that the federal government, including the White House, including the CDC, the Surgeon General, engaged in a suppression campaign by contacting social media companies like Facebook and Twitter and essentially coercing them into taking down the plaintiff's speech, which included things about COVID-19, vaccines, election integrity, generally, according to the opinion, conservative-leaning speech. Now, immediately, the thing that jumps out is the fact that if anyone, you might say that if anyone had their free speech curtailed, it was the social media companies and not the plaintiffs directly. But the court says essentially, because the government engaged in this kind of coercion, that it is potentially a First Amendment violation.
Is the argument here that because the government is so powerful, the White House itself so powerful, that even contacting these social media companies to discuss these kinds of things, even if they don't issue any kind of an order or anything phrased as an order, just that contact could be sort of bullying on First Amendment grounds?
Yes to that contact, but in addition, the opinion notes that the government contacted these companies, just like you or I might, to ask them to take something down. But when you and I do it, they might crumple it up and throw it away. When the White House calls, people listen, not just social media companies, but everybody answers that call. So they took meetings with them. They had email exchanges. But beyond that, when the White House and other government agencies didn't get what they wanted, according to the opinion, they made some not so subtle threats. Like, we're going to have to look at this really closely. We're going to have to look at your immunity under Section 230 of the Communications Decency Act. Maybe we'll have an antitrust meeting. This is something we really need to take a look at. Now, I'm paraphrasing, but what the court concluded is that making those statements went a step too far. We can expect the White House will contact these companies, but to then say, when we're not getting what we want, therefore we might bring the might of the U.S. government against you, that goes too far.
So we see some of these social media companies rallying on the news in the wake of that decision, but I'm wondering what's likely to happen on the legal front next. I would imagine the Biden administration is going to be sure to appeal this.
They will definitely appeal, because these are issues of law that an appeals court might take a fresh look at, particularly the First Amendment issues. Those are always something that would be interesting to an appellate court, which in this case would be a circuit court. But we might see this make its way all the way up to the Supreme Court because of the First Amendment issues involved. And in particular, if I were to target one thing, it would be the idea that simply because the White House makes contact with a company, are they coercing that company to suppress speech, especially when, for example, what if Facebook and Twitter might have done it on their own?
Very short prediction here. If it goes to the Supreme Court, it's a 6-3 conservative court. How does that court handle this decision? You think that the decision stands?
I am a betting man, and I will bet that this Supreme Court will rule consistently, if it gets to the Supreme Court, with this district court's, I think it was a 150-page opinion. So whether you agree with it or not, it's reasoned, plenty well reasoned.
So this could stand. Danny Savalas, thank you.